So please do not speak whenever the hearing is going on or when witnesses are being presented. When it's time for public comment, we'll try to read a few names so you can start making your way to the podium. Be sure when you do start speaking, reintroduce yourself one more time for the record so the court reporter can hear who you are. Give your comments, maximum of 2 minutes, and then step aside for the next person. And a reminder, this is for public comment. This is not a time, you cannot ask questions. This is not to ask the aides or the commissioners or witnesses or attorneys questions. This is just to give your public comment and get it on the record. If you're not speaking today and you want your public comment in, remember we have forms in the hallway, or you can do written comment today. And it's one of our gentlemen in the black shirts with the gold badge, and it will get put into the record in the court clerk's office for you today. So with that, we'll be getting underway here shortly. Just please make sure the devices are off so it does not interrupt the proceedings. Thank you very much.
Okay, we'll note that we'll call this meeting to order. We'll note that notice is appropriate and there is a quorum present. And just as a reminder up front, just to lay some groundwork for what we're actually here on today. What we're actually here on today is what has been posted as several different motions to intervene, motions to continue hearing, and then there are also 5 joint motions to actually hear stipulations and settlement. So I thought it would be good to just kind of lay out some parameters. I know that you've had the benefit, I don't know if he's still in here, of Brandy Reith, our Public Utility Division Director, who has indicated to people we do have a sign-in sheet. So if you have not signed in, it's on the outside. We hope that you will do that. I think he's also asked that if you brought your cell phone in, that you mute those, because that can interfere with the microphone system. So we want to make sure that's done. I had some initial comments to make at the front, again with kind of laying out the parameters for what we're here on today. And then I'll look to my colleagues to see if they have any comments that they would want to make, and then we'll proceed forward. So one of the first items I wanted to mention is I know that we have quite a few landowners here today, right? If you're a landowner, why don't you raise your hand? Okay, very good. Is this the first time that you've ever been present at a corporation commission hearing? Go ahead and raise your hand if it is. Okay, so just to lay out some of the framework, we have our court reporter over here who will take down what is said in today's hearing, and that include testimony from the witnesses, because we're here basically on testimony and evidence that's going to be presented on stipulations that have actually been reached in the case. And this is just a reminder, if you were not aware, the Corporation Commission does not have citing authority. However, that does not mean that we are not concerned about your rights as landowners. And I would just point out that this commission has looked and been concerned about landowner rights for some time. And in fact, I can refer you to the matter of the Clean Line application, which was PUD 2010-75. And in that particular case, there was private agreements that were reached with the company and landowners. And in fact, there's an Exhibit A that was attached that's actually styled the Code of Conduct for right-of-way agents and subcontractor employees. The commission cannot order an agreement like this, but it would be my opinion that the company should make every effort in this regard to ensure that landowners' rights are appropriately addressed. And as I've mentioned, this filing was made on March 1st of 2011. If there's anyone interested in taking a look at that particular filing, if you will look for Brandy Reith, or if you will look for one of these officials that are in the black shirts with the badge, they can provide you the information that you need if you want to access that online. I also wanted to point out that this is the first time that the three commissioners have heard any testimony and evidence on the stipulations that are being presented today. So it's going to be important for us to be able to listen, to hear the testimony, and to take into consideration what has changed since this initial hearing was heard before the administrative law judge and the case was actually filed. I'll also note that Commissioner Hyatt pointed out last week when we were here on this matter that this is a complex case with many economic impacts, and that there would be time that was going to be necessary to make sure we had time to study and analyze this case. So regardless of what you've heard or not heard from many different sources of communications, whether it's email, through the media, or how you've received communication, this is our first time to take up consideration of stipulations and settlement agreements. So if some of you came thinking that we've heard a lot and there would be a decision made today, this is to take up consideration of what is being presented today. So I know some of you have traveled for a ways. I think it's a little cooler in here now than it actually was. So we appreciate your patience and your willingness to listen. There will be a time for public comment. I do note that I believe the Public Utility Division provided a form that some of you could actually, if you were interested, if I could hand one of those to me.
Here's one.
Thank you. There would be a form like this that if you wanted to provide your name and information and provide written comments, you will have the ability to do that. I would indicate to you that public comments, we've already had a public comment period on the case that was originally filed. The public comment today would be to address the testimony and evidence or comments on the stipulation. And remember that some of the stipulation and agreements are for the pre-approval and some are against the pre-approval. So I think it will be helpful for all of you to be here and listen. But if you don't have one of these, if you'll just, Brandy Reith is standing and he's our Public Utility Director. He can provide you with one of these. We will take up the testimony and the evidence first, and then we'll provide for public comment. We will see how far we get along today. And if we are not concluded today, we had already allowed to continue this over to tomorrow at 9 o'clock in the morning and go forward in that regard. So what I would be proposing next, and then I'll see if my colleagues would like to have any comments they would like to make, is that we have quite a few parties that are involved in the case. So we'll look to take the entry of appearances, a very brief statement, and brief means brief, about the particular case or where you stand with regard to the stipulations, and advise us if you actually have a witness. And I'm going to go ahead and mention, since we don't have the benefit of an administrative law judge to hear today's cases, you're stuck with me because I will be presiding over this case. And I would encourage you as lawyers to conduct yourselves appropriately. If you have an objection, stand, use the microphone, wait for your turn. If you have an objection to a continuing line of questions, make the statement instead of jumping up and out of your chair like a piece of popcorn. I would encourage that. So we have a lot of people here that have not had this experience before, and I would urge you to conduct yourselves in a manner that I know the professionals that you all are. I hate it that I even have to say this at the beginning, but I think it's appropriate. This is not a criminal case with high drama, but it is significant and important, and I just want to make sure that we treat everybody fairly and respectfully. So those are some of the groundwork that is laid. I know that the first items that we'd be taking up would be, as I mentioned, 2 motions to intervene, 2 motions to continue, and then joint motions on 5, or rather 4 other stipulations. So at this point, I will ask my colleagues if they would like to make any comments or there's anything that they would like to say before we proceed forward.
Well, I just want to thank everyone for coming today and showing interest in this case. I will tell you we're usually not as popular as we are today, or maybe it's not our popularity that brought you here. I'm not sure, but I thank everyone for showing an interest. This is a very complex case, as Commissioner Murphy has stated, that many parties have been dealing with for many months. It's a case that has major impacts for Oklahoma's future. Oklahoma's not just the next couple of years, but the next 50 years and possibly beyond. And so a lot at stake in this case on many sides of the case. And so I appreciate you showing an interest and being here today.
Thank you. I support the comments that the other commissioners have given. This agency has a constitutional duty when it comes to electric power companies, sometimes called public service companies, like this particular one, Public Service of Oklahoma. Fundamentally, we're interested in reliable, clean, safe, and affordable energy, and to looking to the future for new technology when it's suitable. Commissioner Murphy correctly mentioned that there are several stipulations. For those who are not attorneys, that's like some of the groups to this case, and you can tell there's lots of them, got together and settled some of their differences, and they have settlement agreements that are now before us for us to consider. And I support what I believe I heard Commissioner Murphy saying, that this is not the agency, and I don't think Oklahoma, the state of Oklahoma, has an agency that grants siting authority. Other states do it that way. And I know there's a lot of people who have very sincere interests in their property rights and their surface rights. My grandfather had a quarter section that was dear to us in a similar way. And but that doesn't change the fact that this agency and this case is not one which deals with siting authority. I don't believe that we grant easements, and I don't believe we establish rights of way. That is done in other forums. Yes, we're concerned about every aspect of every case, and we'll go forward. Thank you.
Okay, so Brandy, I don't know if there's any other things as far as housekeeping items that we might need to take care of as far as looking at accommodating those who are here. I know that you have taken a list of names of those who would like to make public comment, and I believe they've been advised they would each have a couple of minutes each, and then we'll see how far we get today and then move over till tomorrow. I want to be accommodating to the public comments, but I think the public comments are more appropriate when you've heard something on the stipulations. I think the comments that you would make ahead of that time, you wouldn't have really heard anything about the stipulations, and that's We have to stay with what we're posted on today by law, and that's what we're posted on. So is there any other items, Brandy, that you think we need to address before we move into taking the appearances and going forward?
Brandy Reith with Public Utility Division. I would just remind folks, if they're doing the written public comment rather than the verbal public comment today, to see any of our gentlemen with the black shirt and gold badge, they'll take those and make sure they get entered in through the court clerks today.
Okay, very good. Okay, thank you. I have been provided an order of presentation, and this is what I would mention as far as going forward with entering your appearances. If you could make sure, if your last name is a bit challenging, if you could spell that for us again, that would be most helpful. So the order that I have, and then we'll go around to take the appearances, are Public Service Company of Oklahoma, South Central, Walmart, Plains and Eastern Clean Line, the Oklahoma Municipal Power Authority, Kiowa Power Partners, Tri-County, Golden Spread, Windfall Coalition, Oneida, the Oklahoma Industrial Energy Consumers, City of Bixby and certain landowners, Novus, the Attorney General, and the Public Utility Division. So, Mr. King, I know you don't need to stand yet, but I know you're going to be representing the City of Bixby and certain landowners. But let's just take all the appearances first, and then I'm going to come back to you after that. Okay, so if we could go ahead and proceed. Enter your appearance. If you have a statement that you would like to make, please make it and let us know if you have a witness.
Your Honor, Jack Fight, Joanne Worthington, and George Hoyt, and that's H-O-Y-T. Here on behalf of Public Service Company, we have entered into stipulations with 6 other parties in this cause and have Mr. Stephen Fate as our witness.
Thank you.
Good afternoon, Your Honors. Please show Deborah R. Thompson on behalf of South Central MCN LLC. I would note that South Central is a party to the PSO stipulation filed on April 24th in this cause, as amended in a filing made on May 30th. And I would also announce that OMPA and Tri-County are also parties to those 2 agreements. And we do have a witness, Mr. Noman Williams, available to testify today.
Thank you.
Good afternoon, Commissioners. Rick Chamberlain on behalf of Walmart Stores East LP and Sam's East Inc. We also have a witness, Mr. Steve Chris, and we are parties to stipulations as Ms. Thompson mentioned.
Okay, thank you.
Good afternoon, Commissioners. Eric Davis, Jim Roth, and Mark Edwards for Plains and Eastern Clean Line. Clean Line has no comments and will be presenting no witnesses. Thank you.
Good afternoon, Randy Elliott, on behalf of Oklahoma Municipal Power Authority. Ms. Thompson has already given you our position. We're a signatory to the stipulation agreement with PSO. Eric Turner.
Excuse me, Eric Turner on behalf of Golden Spread Electric Cooperative. We are a signatory to the Attorney General and Public Utility Division stipulation. We have no witnesses and no comments today. Thank you.
Okay, Mr. Turner, can I just clarify that means that you are taking a position that in the absence of the parameters that have been set forth by the Attorney General and the Public Utility Division, you wouldn't be supportive of an agreement to go forward?
That is correct, Commissioner.
Okay, very good. Thank you. So is there anyone here for Kiowa Power Partners or for Tri-County? Okay. All right, we can go ahead.
Madam Chair, Dean Luthi and Adam Doverspike here for Windfall Coalition LLP. We are parties to no stipulation. We support the objections of the Attorney General and the PUD to approving anything. We advance the legal defects found by your administrative law judge, and we have no witnesses.
Right, thank you. Would you mind to go ahead for the benefit of this court reporter and all of us again, your colleagues, the spelling of your colleague's last name?
D-O-V as in Victor, E-R-S-P-I-K-E.
Thank you. Okay.
Jordan Jackson for Novus Wind Power, Commissioners, and we do not support pre-approval of this project. We are against it, and we also, if given the opportunity, would like to make a brief statement in support of a continuance whenever that's appropriate. And we have no witnesses.
Okay, very good. Thank you. You can remind me, Mr. Jackson, has Novus been involved in this case from the very beginning?
We entered in September, so from September 2017.
Okay, very good. Thank you. Okay, I think we're going a little bit out of order, but that is fine. So I think I had Nita after the windfall. The reason I went in this order is because I believe that was the order that was indicated to me for cross-examination. So if there's a different order, you might let me know, but that was the reason I'd kind of gone through the list. So I don't know, Ms. Vaught, are you for Oneida?
Yes, Chairman Murphy, I'm Cheryl Vaught, and that's V like Victor, A-U-G-H-T, and John Lash, L-A-A-S-C-H, for Oneida Power. And Oneida is a party to a joint stipulation with PSO for the purpose of completing a PSO baseload energy and capacity RFP. Oneida has made a separate filing in this case, a one-page separate filing that states that Oneida does not oppose the joint stipulation between Walmart and OIEC, in which Ms. Thompson's parties have now appended to. And we do have a witness. His name is Mark Strength, and he would be testifying on behalf of Oneida, of course, in regards to the Oneida PSO joint stipulation.
Okay.
Good afternoon, Chairman Murphy, Commissioners. My name is Tom Schrader. I am here on behalf of Industrial Energy Consumers and intervening proceeding. OIEC is a party to the stipulation that was entered into between OIEC Walmart and PSO on April 24th. That stipulation was amended on May 30th. OIEC supports that stipulation. We also entered into a stipulation with PSO and Oneida. We are supportive of that stipulation. We have a witness today who will testify in support of the PSO stipulation. That is Mr. Scott Norwood.
Okay,
Thank you.
very good.
Chairman Murphy and the other commissioners, Eric R. King appearing for the City of Bixby, and also Maurice and Leah Storm, Mark and Becky Fugit, and Mark and Lonnie St. John. We are here on a motion to intervene, and we do not have any witnesses.
Okay, thank you.
Commissioners, Jared B. Haynes, Dara M. Derryberry, and H.A. Snodgrass on behalf of Mike Hunter, Oklahoma Attorney General. The Attorney General opposes pre-approval of this project. He has signed the amended joint statement against pre-approval and joint stipulation and settlement agreement for protections in the event of pre-approval. The amended version of that was filed on Wednesday, June 27, 2018. The Attorney General intends to call Todd F. Borman to the witness stand at the appropriate time.
Could you spell his last name for the benefit of the court reporter?
His last name is spelled B-O-H-R-M-A-N-N.
Thank you.
Good afternoon, Commissioners. Please show Natasha Scott, Lauren Hensley, and Mike Velez on behalf of the Public Utility Division. And we have joined in with the Oklahoma Attorney General in denying PSO's stipulation. We don't have any witnesses today. Thank you.
Okay, very good. I did notice that we have some other elected officials here, so I appreciate their efforts in being here today. So to show some deference to that, if any of the elected officials that are here that would like to come I don't know if we have the podium with the microphone. It's up there. If you want to let us know who you are and that you're here, and if you have any just brief statement to make, this would be the appropriate time if you'd like to do that. And if you don't, we won't make you come to the podium, but I wanted to make sure that that was offered to you. So is there any other elected official that's here that would like to acknowledge or let us acknowledge that you're present? Okay. All right, so we're going to proceed forward in the items that have been posted. So, Mr. King, if you could go ahead and go to the podium, I think that would be perfect. So, I know that you represent the city of Bixby and certain landowners whose names that you mentioned at the outset. There was 2 filings of motions to intervene and 2 motions to continue. So, at this time, can you advise us as to the status, given that we had heard from you last week, and let us know the update on what's occurred?
My pleasure, Your Honor. Eric R. King for the City of Bixby and the landowners. After hearing that was continued last Thursday, then we sat down with PSO and negotiated an agreement with them, which has been provided to each of the commissioners per the terms of that agreement. And they will not object to our involvement, intervention in this particular case. And per the terms of that agreement, PSO has agreed not to bring in the high voltage line into the city of Bixby, which will also take care of the 3 sets of landowners that I also represent. And so we've provided that to the commission, and we would like to just simply pursue the motion to intervene today, make a few comments, and I think that will include our involvement.
Okay, so I think that I had mentioned last week it would be good if we had an order that was provided to us that we could review ahead of today's hearing, so that we understood what was being proposed in the motion to intervene. But it's my understanding that there has been a stipulation agreement, and that would provide the provisions that as I would understand it, for some of the guidance as far as the intervention. Is that accurate?
That's accurate, and we did provide, albeit right before the hearing today, an order for the commissioners in the event they voted to grant the motions to intervene. And because that was set over till today, we didn't know what that vote might be, or whether there would be objections to that, or whether that vote would deny. So we've just provided a rough outline, which also includes the fact that we do not plan on presenting the intervention is granted.
Okay. I think all of us received this just as we were walking into the courtroom. So I will just tell you, my own opinion is to, and always has been, to grant the intervention. But it would be my understanding that the provisions now that you've worked out for the intervention, you've already done that with the company. So I think I could suggest to my colleagues that even if we go ahead and vote to grant the motion to intervene, we could still probably incorporate that as part of any final order. I just haven't had a chance to review and look at this, so I can tell you I'm not prepared to specifically vote on the order that's been presented. It's not necessarily long, but to review it in relation to the stipulation, I haven't had a chance to do that. So I just would note that we could deal with that in an order that would come later, and we could proceed based on the agreement that had been reached with Public Service Company of Oklahoma. So before we get to that, Mr. Fight, do you have any comment or anything that you would make to us?
Our agreement has been adequately described by Mr. King.
Okay. And it's my understanding that there are no parties to the case that object to the intervention? Okay.
I got a quick question. Last week we discussed, are you willing to take the case as you find it?
As I indicated last week, I indicated then that we were willing to take the case as we find it. today, and that's why we said that we would not present any witnesses which would slow down the case or seek a delay.
Well, I thank you for working with the other parties to get this where it is. And for the record, I support the intervention.
Okay, and I guess one last question, Mr. King, and then we'll take up a vote. Were you planning to have some cross-examination?
I'm deferring on that. Probably not, Your Honor.
Okay. And then thank you for on the motions to intervene. So could you give us the status on the motions to continue the hearing? I think you might have told us last week, are those to be withdrawn, right?
Those are to be withdrawn on the motions to get a continuance in the case based on our agreement with PSO.
Okay, very good. So, Commissioner Hyatt, I don't know if you have any comment you want to make, because I'm proposing that we go ahead and take a vote on the two motions to intervene, and it looks like the other two motions have been continued.
I agree with what you've stated, to take a stipulation in a future order and to vote on the motions for intervention.
Okay, and I'm sorry, on the motions to continue, I meant they're going to be withdrawn, they won't be continued. So, on the two motions to intervene, City of Bixby and certain landowners, I vote aye.
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 Okay, very good. We're now going to proceed into the 5 additional items that have been posted on the second page of our posting. And it's my understanding that each of these is a joint motion for the commission to review and consider various stipulations and agreements. So in terms of efficiency and to expedite things, I would be proposing to my colleagues that if we're amenable to proceeding on all these stipulations and hearing testimony and evidence, that we take up a vote on all 5 of these joint motions at one time, and then we could proceed forward into the actual stipulations. So is there any discussion or any other suggestions in lieu of what I've offered as far as taking up the joint motions all at one time?
I would agree.
And so that means we'd have one hearing and cover all the motions at one time.
I don't know that it'd necessarily be one hearing. I mean, we're posted for one hearing, but I'm just looking to, instead of taking each one as a separate item with we need to separately vote on the motion, we'd go ahead and collectively deal with all the motions, meaning we could proceed on hearing things.
Sounds good.
Okay. So on the joint motions for items E, F, G, H, and I vote aye.
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 Okay, so we will now proceed forward with the very first stipulation, which would be the one that addresses the Oklahoma Industrial Energy Consumers, Walmart, LP and Sam's East, South Central MCN LLC, Tri-County Electric Cooperative, and the Oklahoma Municipal Power Authority.
Excuse me, Commissioners. In light of the withdrawal of the motion to continue, Novus requests permission to make an oral motion to continue and make a brief statement in support of our motion.
I think we'll go ahead and allow that. So if you want to go ahead and it might be a little bit out of order since you've actually been here in the case since September. So I want you to know I think we're granting a little bit of leeway, but since you've asked for that, I'm inclined to go ahead and grant that. So if it's easier for you to come to the podium, you can feel free to do that.
Thank you, Commissioner. Thank you, Commissioners. Again, Jordan Jackson for Novus Wind Power. In support of our motion to continue, we'd like to point out that last week, PSO themselves indicated that a reasonable continuance would not push past their deferred deadline, and that even preferred deadline, and even their preferred deadline is not directly related to PTCs. We would also note that PSO has previously stated March 2018 as a deadline, and then April 2018 as a deadline that would jeopardize the PTCs. So if PSO says a reasonable delay, now says a reasonable delay will not jeopardize the PTCs, I think we can trust them. They've been very conservative with when they need a decision by. The reason for our motion for continuance is the interveners, Bixby and Landowner, have brought to light that PSO is considering, at least, or it looks like this point moving forward with a change in the GenTie That equates to roughly 15 to 20% of the length of the GenTie. And just to put that in perspective, the GenTie at its minimum length of 350 miles covers more miles in Oklahoma than I-40 does. And I-40 goes from our eastern border with Arkansas to our western border with Texas. PSO's previous testimony in this case regarding the GenTie route has focused on the northern route with Osage County, and PSO admitted that they were on a tight deadline to get that route done. They also testified that they could not say what a delay or conflict with Osage County would do to the time and the cost of constructions of the GenTie line. They say that in their testimony, so we don't know what a delay would do. Now, again, I point out this is not a small portion. This is 15 to 20% of the GenTie line. And Novus believes that this is a significant change. PSO themselves have said they can't say what impact this would have excuse me, on timing and costs. And we think it would be prudent to allow the Commission and the parties to gather more information and to allow PSO to present information on how this change impacts their time schedule and their costs. We would also note that at Friday after 3 p.m., Oneida filed written testimony in this case. There have been discovery requests of Oneida that are highly sensitive and confidential, which means if somebody wanted to review those and then cross-examine Oneida's witness, they would have had to arrange a viewing, analyze it in light of the testimony, develop questions, and get those questions cleared because it's confidential and sensitive, and do all that this morning before this hearing. PSO and those in support of the stipulations are the ones who requested this hearing deadline. PSO has previously asked for a delay in oral argument so they could continue their negotiations. And so they've really been in control of when this hearing is by requesting it this date, but not giving the information until the week of, or in some cases, the day of the hearing. And in light of all that, Novus believes a reasonable continuance would be appropriate and prudent in this case.
Okay, thank you. Do the commissioners have any questions for Mr. Jackson? Okay, let's hear from the parties. I guess Mr. Fight, and then any other parties, if you'll just stand up, identify yourselves, and give us your position on the oral argument with regard to continuing. Mr. Fight.
Your Honor, we're obviously opposed to any type of a continuance, and I have ordered the transcript. Quite frankly, I was shocked when I heard counsel say that we thought that a reasonable delay would not put the project in jeopardy. I believe our statements of last Thursday were that we needed an order by the end of this month because we had long time lead equipment which needed to be ordered at the beginning of August. And that ties to the PTCs, as you recall, when Ms. Worthington reminded me that I had left that out of the argument. So we would oppose any type of a delay. It's obvious that the parties are here and they're ready to go.
Okay, thank you. Any other parties that wish to make a statement with regard to the oral argument that's been made on behalf of Novus?
Yes, Your Honor. Tom Schrader for OIEC. I'd just like to note that, you know, the stipulation that was entered into between PSO, OIEC, and Walmart was signed April 24th. That was some time ago, and here we are July 1st. I think it's inappropriate at this point in time to grant a continuance. We're all ready to go. There's been plenty of time for parties to do discovery, and we're here and we're ready to go, and OIEC would oppose the motion for continuance. Thank you.
Thank you.
Thank you, Commissioner. Cheryl Vaught for Oneida Power. The Oneida Power PSO stipulation was entered into on May 30th, 2018. That is June having 30 days, 32 days ago. And we have not received one discovery request from Novus. We have not received one phone call from Novus. We have not received one inquiry from Novus. On behalf of Oneida Power, in our opinion, this is dilatory, would not further judicial economy. Parties are prepared and ready to go forward today. Thank you.
Thank you.
South Central MCN LLC, and we are one of the movants that requested a hearing today by the commission, and we would stand by that motion.
Thank you. Any other parties that wish to make a statement?
Randy Elliott on behalf of OMPA, we oppose the continuance at this time.
Please show Walmart and Sam's also opposed.
Any others?
Our PUD would object to any continuance.
Okay, and I just want to say before, I really appreciate the efforts on behalf of the attorneys already. It's been a while since I've been an administrative law judge, really managing an entire case, so thank you for your consideration, keeping things brief and to the point. It's very helpful. So is there any, do you have any rebuttal, Mr. Jackson? If you want to make it, you can make it from where you are.
Thank you, Commissioner. The continuance that we're requesting is based on the fact that the route has significantly changed, again, 15 to 20%. I don't think anybody would argue that a 15 to 20% change in the route of I-40 could increase costs and time delays. And Novus's PSO's testimony on the time schedule illustrated they were on a tight time schedule. It was to a route that goes through Osage County, and they said in their testimony they could not determine or quantify the costs and the delay of a conflict with Osage County. Now they're trying to reroute it through Osage County, and we just don't have the information on how that impacts their time frame and the costs. Thank you.
Okay.
Mr. Jackson, what would your response be to if one of the other parties, and I'm surprised they didn't state that possibly the PTC guarantees and the net benefit guarantees would mitigate the concerns that you've brought forward?
We believe that the guarantees would not completely mitigate a risk with significant time delay and cost delays. And also, one of the Novus's concern has been how this impacts development out in the Panhandle, and a significant delay in a transmission line for 2,000 megawatts tied to a facility for 2,000 megawatts could exacerbate that even more if you have a 2,000 megawatt facility and no line to get that energy out.
Thank you.
And I will just note, Mr. Jackson, I have my own questions for today, and so one of the questions I have will be about, costs and some of the issues that you've raised. So my inclination is to deny, and we'll see what the other commissioners' inclination is to deny your oral motion, but I want to let you know that the concerns that you've raised, I believe, are on all of our minds, and that I will have some questions in that regard. So I don't want you to think that just because we deny your motion that your concerns are not at issue for us. Okay, so on the oral motion that's been made on behalf of Novus, I vote no.
I vote no.
I vote no.
Okay, now we'll go ahead and proceed. Mr. Fite, the way that I anticipated we would proceed, we've got the first, I know what has happened with this stipulation is it started with certain parties and then it was added to by certain other parties, and then I know the one from Oneida is a separate one. So what I'm proposing to do is we take up the stipulation that is involved with all the parties, and although I know that Mr. Fate is going to be your witness, do not be surprised if Mr. Fate is asked a question, because he's on the witness stand, about the Oneida, just in general, some parameters of it. But we'll just see how we proceed, because it might be easiest to try to keep these things separate. I'm just trying to be efficient with regard to the witnesses, but we can blend things too much and then we lose efficiency because it's unclear what we're really on. Does that make sense?
Your Honor, it does. I had intended to, on his direct, to go through both of those stipulations, but if you would like me to bring him to the witness stand a second time for the Oneida, I will do that.
Well, I'm happy to defer to the parties. I just don't want to get confused on what we're actually on. And so I understand Mr. Fate would just be the common witness for both of those, and then I think Oneida has its own separate witness for that. And then on the other stipulation, we've got multiple parties that have their own witnesses. That's the way I understand it. So I don't know if it's best to go ahead and let Mr. Fate give testimony on both of those. So is there any strong objection or is there any suggestion by the parties on proceeding in that way? I just don't want to get confused between those two stipulations because I think they're a little bit different.
They are different, and they're in different sections, if you will, of his direct. But I can do it however the commission wants.
Okay, Ms. Vaught, since it's going to be your client with regard to that stipulation, do you have a suggestion?
Commissioner, thank you for asking, because we do have some overlap here, obviously. I think if we could, without using a lot of additional time, and if it wouldn't be a problem for PSO, put on Mr. Fate as to the broader stipulation, and then I think his testimony, it appears, would be fairly brief. As to the Oneida stipulation, it might be clear for those who are trying to make a decision in this case.
Okay, so you're saying let's just bring Mr. Fate to the witness stand, cover the broad stipulation, then while he's still on the witness stand, go ahead and cover the Oneida, or you're saying to do it separately?
I'm saying exactly what you just said. If PSO does not have a problem with that, I don't want to interfere with your witness strategy or ordering.
I can, either way is fine with PSO, so it's just whatever's
I think it'd be
easiest.
better to have one witness come one time. All this back and forth is time consuming based on my experience.
I think it might be time consuming. I just want to make sure I'm clear, because that stipulation has different parameters than the broader stipulation, and I don't want that to be confused. So let's just go ahead and proceed, and we'll see where we land, Mr. Fate.
Thank you. PSO would call Mr. Stephen Fate.
Mr. Fate, before you're seated, would you mind going ahead and raising your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. You can be seated. So, Mr. Fate, I'm going to do my best to not get confused between Mr. Fate and Mr. Fate. So I hope you'll be forgiving of me if I interchange the names. It's not my intention to do so. And the other thing I would ask you, would you refer to the commissioners to whatever document you're intending for us to look at? Because I know there's been some filed testimony, but refer us to the document if you're going to be asking questions about it. And if we could have page numbers or any references, that would be appreciated.
Okay. The first set of questions, Commissioners, will be regarding the testimony that was filed April 24th, and the conditions will be those that are set forth in Exhibit SLF 1S, which is the Joint Stipulation and Settlement Agreement, attached to his testimony.
Okay.
Would you please state your name, by whom you're employed, and in what capacity?
My name is Stephen L. Fate. I'm employed by the Public Service Company of Oklahoma, and my title is Vice President, Regulatory and Finance.
And did you file testimony in the earlier part of this proceeding and testified on January 8th and 9th where your qualifications were accepted by this commission?
Yes, I did.
And have you since that time filed supplemental testimony in support of the joint stipulation on April 24th, and then additional supplemental testimony on May 31st of this year?
Yes.
Are there any changes or corrections that need to be made to either one of those testimonies?
No.
If I were to ask you those same questions today, would your answers be substantially the same?
Yes, they would.
Your Honor, we would move both sets of testimony into the record.
Okay. Is there any objection? Those will be admitted.
And were you part of the team that negotiated on behalf of PSO with the other parties?
Yes, I was.
And what parties have publicly announced their support for the joint stipulation that was filed on April 24th?
So on April 24th, signatories, in addition to the company on that joint stipulation and settlement, included the Oklahoma Industrial Energy Consumers, or OIEC, Walmart, Stores East, LP, and Sam's. And then additionally, Oklahoma Municipal Power Authority, Tri-County Electric Cooperative, and South Central MCN agreed to an amended stipulation that was filed on May 31.
Okay. I want to walk you through the stipulation that was filed April 24th.
Okay.
And in your opinion, does that settlement agreement contain protections for PSO customers to ensure fairness to the customers, as well as allowing the company to move forward with the project?
Yes, it does. It contains a suite of very comprehensive, strong protections for customers, which in essence provides a strong assurance that customers are going to benefit from the project. In my 35-year career in the utility industry, I've never seen as comprehensive of guarantees and assurances from PSO or electric utility company, and so I think they provide a great deal of protection. The reason that we're able to offer those is because of our confidence in the project and our confidence in the ability to develop of the project.
Chairman Murphy, at this time, I'm going to ask a series of questions that go to page 2 of 19 of Exhibit SLF.
Okay, and can you remind us of, I've got those different testimonies pulled up on my laptop, but what's the date? Is it the 6/21 or the 5/15 supplemental testimony?
The supplemental testimony is that filed April 24th of 2018, is the one that contains the stipulation we'll be discussing first.
Okay, I guess I don't see testimony that was filed in the testimony I have. I'll have all the different ones for Mr. Fate, but I might have it in here, so you can go ahead.
Okay. Again, we'll be on page 2 of 19. Would you please explain the cost cap which is contained in the joint stipulation?
Yes, cost cap is a very important guarantee that the company is providing. It is a hard cap, and that cap is at 103% of our filed cost, or $2,331 per kW, whichever is the lower. That's down substantially from our filed position of 109%. And very importantly, the company has now accepted the risk for force majeure and change in law. So this is a hard cap. So if there's a tariff that is placed on steel, the risk of that is on the company. If there's a weather event that affects construction, the company has accepted responsibility for that risk. So when I say a hard cap, it means a hard cap. There's no exceptions to that. The other change from our originally filed position is we've accepted or have included the AFUDC expenses in the cap as well. So that provides additional protection for customers if there's a schedule delay or anything of that effect that could increase the carrying cost during construction. So this is, in essence, a not-to-exceed price that we are guaranteeing for customers.
Now, does this hard cap also include the cost of the Gentie line?
Yes, it does. It includes the cost of the wind farm, the Gentie line, as well as any SPP interconnection costs that may be assigned to the project.
Did any other parties suggest a cost cap during the hearing?
Yes. OIEC witness Norwood, Attorney General's witness Borman, as well as PUD witness Mossberg, all recommended that there be a cost cap.
What is the PTC guarantee?
PTC guarantee is another very important guarantee because, as you know from prior testimony, the economics of this project are driven very significantly by the federal production tax credits that will be earned through the generation of the project. So what the guarantee is that for rate-making purposes, the project will be eligible for 100% of the PTC value. The PTCs, federal PTCs, are being phased out, and so we are guaranteeing that the project will be available for 100% of the value of those federal PTCs. There's only one exception to that guarantee, and that is if there's a change in the federal law or the IRS code that causes a change in the value of those PTCs. But in another provision, which I'll talk about in detail, the net benefit guarantee, in the event that occurs, it gets scooped in with a bunch of other factors to ensure that overall customers will continue to benefit from the project.
That's something that I've had a question on the last few days, and you've confirmed that it was my understanding that the PTC guarantees did have an exception for law, but yet the net benefit guarantee would supersede that in the event there was a change in law. So why even have the PTC guarantee? I mean, I'm sorry, why even have the change in law exception?
Well,
I know why the PTC guarantee is in there, but
yeah.
Why have the exception?
So we think there's a very, very small likelihood that there'll be a change that will affect the value of the PTCs. But it's one of those very small probability but high impact events. And so we thought it was appropriate that that risk be shared between the customers and the company. But as I pointed out, in the end, the customers are still guaranteed a benefit through that net benefit guarantee.
So the net benefit guarantee really makes the exception null and void. Not null and void, but it makes it worthless to you.
No, I would say it mitigates a lot of it to customers. It mitigates a lot of that risk to customers.
Thank you.
Mm-hmm.
The production tax credits are overwhelmingly important to the costs or financing of the project. Is that right? And if so, can you give us some idea as to how much money over, isn't it a 10-year period of time under your proposal?
Yes, Commissioner Anthony, it is important. It's an important component of the economics. Over the 10-year period on a net present value, let me double check my notes here. On a net present value, about $688 million. However, if those go away through that net benefit guarantee, customers will still receive a benefit under our projections.
Would you say that the $688 million figure is a benefit to consumers?
Yes, it absolutely is. It's an offset to the revenue requirement of the project.
It's not shared with the shareholders.
No, Commissioner Anthony, it flows 100% of the PTCs flow through to customers.
And I was trying to reread Witness Godfrey's testimony, and he gave his testimony for your company, PSO. Is that correct?
Mr. Godfrey was a witness, yes.
All right. And based on what you know, the start of production occurred so that you qualify for the 100%. That's what you've said. Is that right?
The start of construction, yes, and meeting the continuous construction requirements of the IRS code is what makes the project continuing to be eligible for the full PTC value.
but the clock for the 10 years to run to get on your estimate of $688 million starts when there's operation, not just the start of construction. Is that right?
Yes, that's correct.
And I guess this figure that the federal tax laws gives us changes with an inflation adjustment, but it started off 2.4 cents per kilowatt hour. Has it changed since then?
I don't know what the change is. I assume that it has been adjusted for inflation, but I've not looked at specifically what the number is. Okay. But I would assume it has, yes.
Well, I'll admit trying to figure this out was one of the most challenging parts to me, so I appreciate your patience. Thank you. Nothing further.
And I think my light just came on the question that I was asking and what you were trying to explain me. I think what you're saying back to the PTC guarantees and why have the exception for change in law. What you're saying with the net benefits guarantee, and this should have been obvious to me, but it wasn't until now, the net benefits guarantee, there could be so many other benefits that the PTCs are not needed. That is a possibility. But in the event that they are needed, they would still be captured in the net benefits guarantee. But in the event that they're not needed to give the customer a net benefit, they would not be capped. They would not, or the company would not be held accountable if the PTCs went away.
That's right. Well, I would have said it a little bit differently, but I think that's right. Is that the net benefit guarantee takes in a variety of benefits and does that calculation to assure that whether it's the amount of generation and fuel savings, or whether it's avoided carbon cost, or whether it's prolonged low natural gas prices that are much lower than what we projected, it provides assurance that depending on what combination of those events may occur, that there's a benefit for customers in the project. So I think I said the same thing a little differently.
To the farmer. We do say things differently, don't we?
Actually, I'm an engineer, so.
Engineer, I'm sorry. Even better.
All right, Mr. Fight, steer us back to where we need to go on the stipulation.
Okay. Did any other parties suggest a PTC guarantee?
Yes, both IEC witness Norwood and PUD witness Mossberg both recommended a PTC guarantee.
And would you please explain the net capacity factor guarantee?
This is another one of the very important guarantees because as we've talked about the energy that comes out of the project, there's savings associated with basically since there's no fuel component to it, there's an energy savings out of each megawatt hour. So we talk a lot about different capacity factors, but in the end what we're really getting to is an energy number. How many megawatt hours is the project going to generate over a specific period of time? And so what this net capacity factor guarantee does is provides assurances that the project is going to generate 12,105 gigawatt hours over a 5-year period. And so there's five-year periods over the 25-year life of the project. And at the end of each one of those 5 years, we'll go back and look and see what the generation was, and if it was under that, we will calculate a replacement energy and a replacement PTC value and make make whole payment to customers. So not only this is important for two reasons. Number one is the replacement energy, but there's also a minimum PTC generation. So for every megawatt hour, there's one PTC that's generated. So this guarantee is not just for energy, but it's a guarantee for the amount of PTCs that are generated from the project and benefit customers.
Did any other parties suggest a net capacity factor guarantee?
Yes, they did. Again, OIEC witness Norwood Attorney General witness Borman, and PUD witness Mossberg all recommended a net capacity factor guarantee.
Okay. You've already discussed this somewhat, but would you please describe the net benefit guarantee?
Sure. This is and a little bit like a broken record here, but this is another very important guarantee. And it works in it's a complementary to the other project performance and cost cap guarantees. I characterize it as more of a safety net, if you will, in the case that any combination of those guarantees plus others work to reduce the benefit of the overall benefit of the project. This safety net or net benefit guarantee will make a calculation and determine that whether the project had a net benefit for customers. So this occurs over the first 10 years of the project, where the PTCs are generated, and then in year 11 we will do a calculation pursuant to this methodology to determine whether there was a net benefit to customers. And if there's not a showing of benefit by this calculation, then in the remaining year we'll create a regulatory liability in that amount and refund that balance to customers over the remaining life of the project. So one of the things that's important about this methodology is we tried to make it as straightforward as possible. So that way everybody knew how we were going to calculate it, and it would hopefully forego a big battle of the models in year 11 that could occur if you have more uncertainties in the methodology in which you're trying to calculate that benefit.
If you recall during the proceeding, or I should ask you, do you recall during the proceeding that there was a lot of testimony regarding whether or not there'd be carbon, whether or not avoided carbon should be in the model, the loss of a PTC, or low natural gas prices? How does the net benefit guarantee address those types of issues?
In the calculation for the net benefit, there's a variable in there for the three items that that Mr. Fite has mentioned. So if you're worried about whether there's going to be a carbon savings, or if you're worried whether there's going to be historically low natural gas prices for extended periods of time, or as we talked about earlier, Commissioner Hyatt, a loss of PTC value, then this net benefit guarantee captures all of that and provides that safety net in the event that the assumptions that we've made in our analysis don't prove to be, or that those factors don't develop the way we've expected them to.
Has the company's position changed regarding including a change in law or force majeure provision in the stipulation?
Yes, it has.
And how has that changed?
Well, in the prior settlement and in our pre-filed testimony, for the most part, the provisions that we offered to provide customer assurances, the company was not taking on change in law and force majeure risk. In the stipulation that is before you now, the company is taking the vast majority of that risk. So, as I said on the outset of my testimony, this is a very, very actually incredible set of guarantees that the company's offering to customers.
What additional guarantees are contained in the stipulation, and can you advise the commissioners as to whether or not any of those are the same as are contained in the AG PUD stipulation?
Yes, there's numerous guarantees and provisions that provide additional benefit and protections to customers. They're minor relative to the ones that that we've talked about so far, but those include incremental off-system sales margins. The company's agreed to flow 100% of the off-system sales margins from the project to customers, and that is And then there's the most favored nation provision. This provision's been expanded from our previously filed position to be very comprehensive and to cover basically any terms or conditions in which our sister company SWEPCO agrees to, either through a settlement or order in their 3 state jurisdictions. So it's a much more expansive provision. There's a protection for the Oklahoma allocation of the project in the event that one of the SWEPCO jurisdictions does not authorize approve the project, then it assures that Oklahoma customers are not going to recut the deal, that the Oklahoma allocation is going to continue to be the same. There's a deferred tax asset balance cap, and that protects, there's limits and protections on how much of a average balance for that deferred tax asset can build in the event that the company's tax appetite is not sufficient in the year that the PTCs are earned and flowed to customers. So there's a limit on the company's return on that asset. And then the last one I'll mention is the development cost. The company has agreed to or is accepting the risk for the development costs of the project to ensure that it's still eligible for 100% value of the PTCs, and that the shareholders are taking that risk, and we will not seek recovery of those costs unless the commission approves the settlement and we move forward with the project.
We've used this term off-system sales. If there were power generated in the panhandle of Oklahoma and it ultimately was sold to Arkansas or Louisiana, is that an example of an off-system sale?
Not for the purposes of PSO and PSO customers. So we would take our ownership share, which is 30% of that project, and since it connects into a substation in Tulsa, it will be settled at that price in Tulsa. So PSO and PSO customer share settle at the Tulsa hub.
I've had people, I think, criticize this project, and they say it like, why should PSO customers pay to build a system so that Arkansas and Louisiana would enjoy the power? I think you may have responded to part of that, but please continue.
I'd be glad to address that concern. Actually, the fact that PSO and SWEPCO are able to collaborate on this project actually brings benefits to Oklahoma and PSO customers. There's tremendous economies of scale that are achieved by building a 2,000 megawatt wind farm versus a much smaller one. So by the fact that the project has been optimized at as large as it is, both the size of the wind farm and the size of the gen-tie means that the overall cost per dollar per kW or dollar per kWh, however you want to look at it, it's lower because of SWEPCO's participation.
So back to the 30% that is PSO in Oklahoma, give me an example of who would be buying the power on an off-system sale.
It would be clearing into the SPP integrated marketplace. So in essence, it's cleared in the SPP market.
And so would you think the more that there was of off-system sales, the better for the economics of PSO customers?
Yes.
I used to be in the clothing store business. I'm telling you, the more sales it was, the better. And so you're saying that the 100% of any margin, can I call that profit, that would occur would go to the PSO customers?
That's correct.
Nothing further.
Do these guarantees that you've discussed this afternoon, do they apply to all customer classes?
Yes, the guarantees apply equally to all customer classes.
Are there any provisions in the stipulation that apply only to certain customer classes?
Yes, but it's not a guarantee provision. There's one minor provision that allows service level 1 through 3 industrial customers to purchase, to nominate, I'll say, RECs specifically from the Wind Catcher project. And that's important to a lot of our commercial and industrial customers because of their corporate goals. And one of the goals is what they call additionality. And what they want, what some of our industrial customers want, is to be able to say, we're supporting the addition of renewable resources. So by allowing them to nominate RECs through our wind energy choice tariff, which is currently in place for all customers, but doesn't currently allow a customer to nominate a specific wind farm that they're getting their renewable energy credits from. This particular provision for our large commercial and industrial customers allows them to meet corporate objectives.
Are there any provisions in the AG PUD stipulation that are the same as found in the PSO stipulation?
Yes, some of the more minor provisions are the same, specifically the retail customer revenue requirement allocation, the deferred tax asset balance cap, and development costs are the same, but there's many more differences than there are similarities.
Okay. Commissioner Murphy, we're still in the same stipulation that's attached to the testimony filed April 24th. Would you please explain the amendment to the joint stipulation and settlement agreement?
Yes. Subsequent to our agreement with OIEC and Walmart, we continued to negotiate and reach an agreement with OMPA, Tri-County Electric Cooperative, and South Central MCN. And as a result of that agreement, we amended Attachment 5 to the joint stipulation and settlement. And the amendment addresses two issues that spring from the fact that the project is overlapping some of Tri-County cooperative service territory. And those two general provisions deal with retail service and then interconnection facility ownership rights. So the important thing to note here, most importantly, is that none of these provisions in Attachment 5 negatively affect PSO retail customers.
Okay. I would like to handle the Oneida stipulation separately. So I'm going to ask you, have there been settlement in other states that would be similar to the one that you've just described?
Yes, there's settlement in two SWEPCO jurisdictions, both in Louisiana and Arkansas, and those stipulations have been approved by the respective state commissions. They have similar provisions, but the good news is that the stipulation that PSO has entered into has more stringent requirements and more customer protections than either of the other state jurisdictions.
Now, Commissioner Murphy, we're going to move to the testimony and the stipulation that was filed on May 31st of 2018 regarding Oneida.
Okay, so you want to go ahead and do that, and then I guess we're going to have it where when the parties get up to cross-examine, they're going to have to make it clear to us which one they're actually cross-examining on, right?
That's right, or I could do it, I keep saying, or I could do it separately.
I think we'll go ahead and proceed like this, but I think when we get to cross-examination, that might be a little more challenging, so I think the parties will just have to make it clear which stipulation they're on. So the very first stipulation was Walmart and OIEC, right?
And South Central and OMPA.
And then we had an amendment, and then that took in Tri-County.
Okay, I see what you're saying.
I'm trying to look at, there's
okay.
layers. There's a stipulation,
and
then there's another chain, there's another parties, and then there's other I thought there were three of those,
Okay,
and then there was the Oneida.
I didn't understand your question.
Okay, am I looking at it right?
Yes, there was the first document, and that was signed by Walmart, OIEC, and PSO. Then there was the Exhibit 5, which was an amendment to that document, and which is contained in the stipulation with the April 24th testimony that had South Central, OMPA, and Tri-County Electric.
Can I try one more topic before we move to the next document? Some people have, I don't know if they've criticized, but they've been skeptical or criticized wind projects in Oklahoma because there was foreign ownership, or these tax credits were going to out of state or out of the United States foreign investors. Does this project, I know it involves Invenergy, they do business worldwide, General Electric does business worldwide, AEP is a pretty big company. Are there aspects of this project that involve foreign ownership?
No, not to my knowledge, and the folks that you mentioned are the developers, and in the end, PSO and SWEPCO will be the owners of the assets, and there are no Oklahoma tax breaks that the project is eligible for. So there's no Oklahoma tax breaks going to any foreign entities.
Thank you.
Okay.
Mr. Fight, before you go on into the Oneida, is there going to be similar testimony about the cost caps, or is that's going to be something different because Oneida is different? Is that right?
That's right.
Okay, I'm still going back to, I know Commissioner Anthony had his question, but help us get back to what I was asking before. There was the first stipulation, then there was additional parties that came on, then was there a third one before the Oneida, or is the Oneida, there were two, the basic one, then additional parties, then Oneida? Is
And
that
then
how it
Oneida.
worked? Okay. All right, so I have some questions about a few questions about the other stipulation, the first one.
Okay.
So I still think it's going to be better to do Mr. Fate separately, and I think we'll work it out. But I guess my question, Mr. Fate, is the Attorney General and the Public Utility Division staff have proposed, instead of the hard cap of 103%, they've proposed a hard cap of 100%. So I have a few questions just around there. What is the price differential between 100% price cap and the 103% price cap?
You should have brought my calculator. I think.
Are we talking hundreds of millions or tens of millions, or do you have any range?
I think it's around 30 million.
30 million, okay. And then in the hard cap proposed by the PUD and the Attorney General, were there contingencies already built in to what was being proposed as a cost cap? Weren't there contingencies already built into that 100% number?
Yes, there were. It was about 7 to 8% of the project cost were contingencies, and that's very consistent with a project of this nature. It would be, frankly, imprudent to have a project without those type of contingencies. But it's important to note also that when we developed that estimate, we didn't include change in law or force majeure risk. So under the cap that we've proposed, we've taken both of those very substantial risks, and they were not originally contemplated in our original estimate.
Okay, just generally, what's the anticipated cost of the project for the Oklahoma portion?
Yeah, around and I'm rounding, 1.4 billion.
So you already provided 7 or 8% contingencies of the 1.4 billion. So what does that come out to?
I'm sorry, say again?
Okay, so you said that you provided already within, if you were looking at 100% cost cap, you provided contingencies already of 7 to 8%. So I'm asking, what is 7 to 8% of $1.4 billion?
I think it's around 350 million.
Okay, and so was your earlier statement to me that you feel like these other items that you've talked about, where you're guaranteeing with regard to if there's a change of law, that you feel like that offsets the $350 million of contingencies?
I think the way we've looked at it, Commissioner Murphy, is we've looked at the overall risk of the joint stipulation and settlement that we've agreed to. So while you know, there's a certain amount of risk associated with one item, the way we've got comfortable with it is looking at the overall risk. And again, we've taken a substantial amount of risk by putting these guarantees in and taking the force majeure and change in law. So we've taken just about as much risk as we can overall through the stipulation that we've proposed.
Okay, but between the 100% and the 103% hard cap, who bears the risk of that 3% of the cost cap? Do the customers bear that risk?
Well, let me put it this way. Every dollar that we spend up to the 103% cost cap is subject to a prudence review. Our stipulation settlement defers the prudence of each of those dollars until after they're spent, and you can see why they were spent, the justification for each of those dollars, up to 103%, but each one of them has to have been spent prudently.
Okay, so are you saying then that if this commission were to grant pre-approval, that prudency is not granted?
No, if the commission approves the joint stipulation and settlement, it will have determined that there is a need for low-cost energy and that the project meets that need for low-cost energy. So the project is prudent, but then at a point in the future, once the costs that have been spent are known, you can then look at each dollar spent and determine that each one of those dollars was spent wisely and should be recovered from PSO's customers.
Okay, so then are you saying that pre-approval under the 286 portion of the statute, that need can be based on whether it's a low cost or whether it's low cost or economic power, that's how a need can be established, regardless of whether you need, you know, additional capacity or to meet load? Is that what you're saying?
Yes, and the commission's found that in prior cases as well. In several of our prior wind deals, the commission has found that there is a need under 286 and that for low-cost energy, and that the contract that was under consideration at the time was a reasonable alternative to meet that need for low-cost energy.
Okay, and was what's being proposed here today, was this ever a part of any integrated resource planning that Public Service Company of Oklahoma did earlier?
Yes. So in our 2015 Integrated Resource Plan, which was issued prior to the extension of the PTCs, we had, you know, I'd have to go back and refresh my memory, but roughly 600 or 700 megawatts of wind over time added to our portfolio. So when the production tax credits were extended, we went back and looked at that integrated resource plan, updated it in 2017 to look at what is the impact if we accelerate the megawatts of wind that were in the plan, if we accelerate those to take advantage of the 100% value of the PTCs. So we had 600 megawatts of wind in our 2015 Integrated Resource Plan, and we basically validated the assumptions that and our analysis that we did in Windcatcher through the update of the Integrated Resource Plan in 2017.
I think I may have more questions back on this stipulation, but I think let's go ahead and go further into Oneida because I want to see what some of the cross-examination might be. But I still have some questions around this prudency component and what it would really be that the commission, if the commission pre-approved, what that really is. Prudency for the entire project, for the life of the project. That area feels a little bit spongy to me. So, Mr. Fight.
Could I just clarify one of your statements to Commissioner Murphy? Commissioner Murphy was asking you about the contingency fee. We know 7 to 8%, and she asked you about the $1.5 billion and what's the dollar value, and you stated $350 million. $350 million would be the total project, wouldn't it?
Total contingency.
Total contingency, not
Yeah.
Oklahoma's portion.
That's my understanding. Correct.
In other words, 7% of $1.5 billion is closer to $100 million than $300 million. Okay.
Thank you, Commissioner, for that clarification. That's correct. That would be out of the $4.5 billion of the project. $350 million is 7 to 8% of 4.5. That's correct.
Okay, so back to the, and I appreciate that clarification. So the $350 million, that's not the Oklahoma portion. It's just
That's total project. That's correct.
okay. All right.
Thank you. Has PSO reached an agreement with Oneida?
Yes, we have.
And that agreement was actually dated on May 30th, but your testimony that supports that agreement was filed on the 31st. Is that correct?
Yes.
Okay, would you please describe that agreement?
Yeah, at a real high level, there's a couple components that are important to note. It contemplates that PSO and Oneida would enter into negotiations for a 20-year PPA based on the proposal that they had submitted into our 2016 RFP, and for 300 megawatts. And it also contemplated that we would have that agreement executed by the end of June, and we did have that completed on Friday, so we have an executed agreement with Oneida. The other part of the stipulation calls for PSO to issue another RFP. So our last integrated resource plan update in 2017 said that we had a 458 megawatt need for additional capacity in starting in 2022. And so the Oneida PPA fills part of that need, and within 9 months after approval of the stipulation, PSO will issue another RFP to fill the remainder of that need through a competitive solicitation process.
And in your experience at PSO, do you have experience in procuring power for the company?
Yes, I've been working in purchase power, resource planning, and competitive bidding for about 20 years.
And is this a gas-fired facility?
Yes, it's a natural gas-fired combined cycle plant located in Coweta. It's called Oneida, which is right next door, so but in a suburb of Tulsa, we'll say. We have an existing PPA with the facility that started delivery in 2016 and has been a very successful and cost-effective resource for us. And what I think is really good news for customers is that when we begin taking delivery of energy and capacity from the facility in 2022, PSO customers' rates will actually go down as compared to the PPA that it's replacing. So I think that's indicative of how good of a deal it is for PSO customers.
Have you had the opportunity to read Oneida's testimony?
Yes, I have.
And do you agree with their characterization of the PPA?
Yes, I agree with Mr. Strink that it is a very competitively priced purchase power agreement.
Have you had an opportunity to read the testimony of AG Witness Borman?
Yes, I have.
And do you have any comments regarding that testimony?
Yes, and I think it's important to note that the agreement that Mr. Borman supports with his testimony is not really a settlement, even though it's characterized that way often. It's pretty much representative of PUD and AG's litigated positions, and in some cases it's more stringent than their litigated positions. So it's really an agreement that's untenable for the company, it's untenable for the project, and I think it's fairly transparent that what the intent of those are is to kill the project, which is really what they want the commission to decide. They say right up front they don't think the project should go forward, and all of the conditions that are much more stringent than the ones PSO stipulation includes, of which Oklahoma Industrial Energy Consumers and Walmart have signed on to, it's just not tenable for the project. So we think that that the conditions in the AG's stipulation are punitive to the company and not necessary, because with the assurances that PSO is offering, we've already essentially guaranteed that customers are going to benefit. So there's no need for any more stringent requirements to ensure customers are protected. As I've said from the outset, this is, I think, an unprecedented project, and Commissioner Hyatt, as you indicated, it can affect Oklahoma for many, many years, and I believe it will affect Oklahoma very positively for many, many years. And if we don't go forward with the project, I think it's a huge lost opportunity, because it will leave PSO customers exposed to more vagaries in the energy industry. And so this is kind of a once-in-a-lifetime opportunity to bring such a valuable asset to the state and to PSO customers that provides an effective hedge and diversifies our energy supply.
Your Honor, with that, I would tender the witness for cross.
Okay, Mr. Fate, I just have a few questions. Is it accurate to say that the agreement was entered into at the end of June 30th, 2018, but the delivery doesn't occur until June 22 through May of 2042?
That's correct.
So I heard you use the term competitively priced. That's different than competitively bid, right?
No, not in this instance, because this was a result of the 2016 RFP that we conducted to identify and secure low-cost natural gas-fired resources. So the Oneida proposal was shortlisted and one of the top bids from that competitive solicitation, which was monitored by PUD staff.
So you're going back to an RFP or a solicited bid that basically, I thought it was negated, and then it was to move forward with this particular plan. So you're just going back to pick up what was done and look at one of the parties that was a finalist and saying that that was competitively bid? Is that how you're looking at it?
It is a product of the competitive bid process. You're right, we did put a hold on that RFP process when we announced Windcatcher. And what we did was picked up where we left off and did final negotiations with one of the top bidders.
Okay. Was there a need for this power shown in any of PSO's IRPs?
Yes, ma'am.
Okay. And will this replace other generation, or will it replace market power that would otherwise be obtained by PSO?
Yes, we have a PPA that's expiring at the end of 2021. That's approximately 520 megawatts. And so this replaces that capacity and energy from that PPA that's expiring.
The RFP that you let out in 2016, where you said that Oneida was one of the finalists, were there other companies that were also finalists as a part of that process?
Yes.
So it seems to me like basically as a result of that process, you just went back to one of the companies that was the finalist and reached this agreement. I mean, did you go back to any of the other companies?
No.
And is there any other information you can give us about that? It just seems, I understand the RFP was let out, but it looks like there was finalists, but we choose this one and then we're going to say it was competitively bid, but it seems to me like it might have been competitively priced.
Well, as I said, I think it's both. And I hate to characterize the other bidders too much because it contains confidential information, but I can represent to you that they were not, they were for larger tranches of capacity that were too large based on our reduced need, so they didn't fit as well into our overall need as the Oneida PPA did.
Okay, so on the PPA that was part of the RFP, was it for this same time period?
Yes.
June 22 through 2042 for a 20-year period, not to start except for 4 years from now?
Yes, the RFP actually was for a minimum of 10 years, and this was a 20-year bid.
Okay, and I have other questions, but they're back to the other stipulations, so I'm just going to hold those, and I'll just wait and see, because somebody on cross-examination or somebody else, you may come back to some of those, Mr. Fight. So do the commissioners have any other questions at this point in time, and you may have some others later?
This may come in cross-examination, but in case it doesn't, and I forget about it between now and then, I want to ask. You said that the stipulations that the AG PUD stipulation put in place, of course, there are some that overlap with the stipulation that you've agreed to, and then there are those that do not. And you stated that those, or maybe at least many of those, would render the project untenable. Would that be 100% of those non-overlapping provisions, or are there specific ones that stand out to you as being the ones that make the project most untenable?
Well, the devil's in the details. I can say that there's a couple of them that are borderline egregious, and those are the net capacity factor guarantee, and then what they call their hold harmless provision, which is similar to our net benefit guarantee. What they've proposing, which just doesn't work, is that the company provide a guarantee and every year. Okay, so under the way that they've proposed it, if the company, if the project saved customers $100 million 3 years in a row, and then in the fourth year it lost $50 million, even though customers over that time period would be ahead by 250, their methodology makes the company cough up $50 million to customers because in that 1 year it didn't meet the guarantee. And that's just not right. It's not fair, especially when the project in total would be performing extraordinarily well. And so just because in 1 year it didn't meet that average, the company had to pay customers, just isn't fair.
And I assume that was probably your position on the AG's annual calculation, but PUD, I believe, came in at a 5-year calculation, and your agreement calls for a 10-year calculation. Am I correct in that?
Oh, on the net benefit guarantee, yeah, we think that the guarantee needs to be over 10 years to where we have the benefit of all the PTCs. And the more granular you make it, then you're going to be in a situation where, like I described, where overall the project may be substantially benefiting customers, but because you've sliced and diced it, you're adding risk to the company without, unnecessarily, because the guarantees that we've provided already are going to assure that customers benefit from the project.
The other one you mentioned was the guaranteed capacity factor, and I'm working from memory, but I believe PUD AG proposed 52%. Is that somewhere in the
52
neighborhood at
and
least
change,
for
right.
discussion purposes? And you're proposing 45?
46.
46.
Mhm.
And the 46 comes in at a 95%. The way I understand that, and I've been confused on that P95 issue before, but we're saying that there will be a 46% capacity factor 95% of the time.
Correct, but for, we increased that from perhaps the last time you looked at it, so it is a P90. So there's a 90, so we've increased it from what was the P95 number. So we've added additional guarantees and benefits for customers. And just by happenstance, another way to think about that is we're guaranteeing 90% of the output of the project. So that's a pretty substantial guarantee.
One that I came across that I was at least interested enough in that I want to seek more information because it made sense to me on the surface, but the AGPUD called for a provision that the carbon savings would only be used in the calculations if a carbon savings were implemented, and currently there is not a carbon tax currently, and so so PUD AG said we'll let it happen, but only if the government puts in place a carbon tax. Is that one that you might fall into a bucket of being exceptional? Or
no, I think
acceptable, not exceptional.
So if you look at our calculation, it in essence does the same thing. There will only be a savings imputed in the calculation if there is and maybe I ought to look at the exact language, but if there are a carbon tax applied to PSO's fleet that would be avoided because of the generation, that's the only time that we would pick up a savings from avoided carbon.
Okay. Yes, I hear what you're saying. Now, my reading of, and this I'm sure is going to be clarified in cross-examination, and so we can just wait until that point. It just appears to me that maybe there's two different positions on whether that carbon savings is used in the calculations or not.
So the carbon savings provision in attachment 2 of our settlement says any costs on the production of carbon that actually would have been incurred by the company's fossil generation fleet as a result of a federal mandate imposing a cost on the production of carbon from fossil generation, but for the project.
Okay. I'll let someone that knows more about their own position than I probably know about their position, and I'll let them talk to you about it. Okay.
Mr. Fate, I want to go back just quickly again to make sure I understand back on the prudency. Are you saying that if the commission approves this stipulation, that are agreeing with the prudency of the project?
In essence, yes, that you found that there's a need and that the project, there's a need for low-cost energy and that the project is a reasonable alternative to meet that need.
Okay. Do you think that means that the costs would still be subject to a review for prudency in a future cause or not?
Yes.
And do you know what the basis is for your position on this last one? That the prudency of the cost component would still be, is still something that the commission could take up at a later time?
Well, I'm not going to venture into the legal argument, but that's specifically what we've requested in the stipulation. And so I think an important part of that future prudence review of the cost is the fact that we have capped the cost exposure for customers. So you can determine that there is a need and that the project is a reasonable way to meet that need because we've capped the cost to customers.
Okay, and we heard Mr. Jackson bring up the issue, and I know it was brought up last week, about the changes to the route, some different components of the Gentie lines. So has there been additional cost, or has there been a review of what a change in the route might be? Because it's still my understanding there's still not a definitive plan for the route at this point in time.
So you're correct. The final route, overall route of the line has not been locked down, but we're very, very close to that point. I can't, and I don't know that we have completed a complete cost assessment of, since the route is not completely locked down, but what I can tell you is that we have that 103% cost cap in place, that hard cap. So irrespective of the cost for a route change, it will all be
Today that the route hasn't been locked down and there might be some tower changes, that there's not going to be really an impact to the benefits and costs because they're all going to be subsumed in this 103% hard cap cost?
Yes.
And is that what the stipulation says?
I believe it does, yes. It doesn't specifically call out transmission route changes or other contingencies, but I think it's, and if it's not clear, I'm here today to make sure that it's abundantly clear that those changes are under the cap, to be included under the cap.
And that's even making that statement without really knowing exactly where the route's going to go at the point in time.
Yes.
Okay, all right, thank you.
And I don't know if that was, I can't remember exactly how it's worded in the stipulation, but I know, and I believe it was your testimony, but some previous testimony, there is a very definitive statement that the amount above 103% would not be, it would not be a possibility to come for recovery.
That's correct, Commissioner Hyatt. I think that's in some of my supplemental testimony.
So then if I could ask one question in light of those other questions, the guarantees that you've been discussing, they all go to, or most of them would go to the rate impact on customers?
Yes.
Thank you.
All right, I think I've got an order, the batting order, and you can let us know if you have any questions. South Central. Walmart.
No questions.
Plains and Eastern Clean Line. Mr. Davis. I didn't see him. Mr. Davis, we got to make sure our court reporter can see. So I'm just going to repeat that you said Eric Davis for Plains and Eastern Clean Line, no questions, right?
Correct, Your Honor.
Okay, thank you. Oklahoma Municipal Power Authority.
No question.
I don't think we ever had an appearance for Kiowa Power Partners, as far as I understand. Tri-County. Golden Spread. Mr. Luthi, why don't we just hold on you just a moment, if you don't mind? I don't know. Are you going to have questions? Okay, why don't we hold on that just a moment? Oneida, do you have questions on the bigger stipulation or just the stipulation with Oneida? Why don't you hold for just a second, okay? Mr. Schrader? Hold just a second. I'm trying to get a feel for who has questions. City of Bixby? Novus? You will? Okay. And I'm assuming the Attorney General will have questions. Is that right, Mr. Haynes?
Absolutely.
Okay. And is the Public Utility Division going to have questions? Mr. Velez? No questions? Okay. So we're going to go back and we'll pick up Ms. Vaught with you. Mr. Luthi, we'll come back to you.
Good afternoon, Mr. Fay. I just want to make sure the record is clear, and so this is going to be a little bit of a long question, but I think it'll make it go very fast. Mr. Fay asked you about the broader wind catcher stipulation first, correct?
Yes.
Then next asked you about the Oneida stipulation, correct?
Yes.
This is now a three-part question, by the way. And then he asked you about the AG's testimony as from Todd Borman. Do you recall that?
Yes.
When you were speaking in response to his questions about the AG testimony, about the project, were you referring to the wind catcher project?
Sorry?
When you were speaking in response to Mr. Fite's question regarding Mr. Borman's testimony, he asked you several questions, and you kept using the term project. Were you speaking about the wind catcher project?
Yes, I was. I think Attorney General Witness Borman was silent on the Oneida STIP.
That's all I needed. Thank you, Commissioner.
Okay, I know, Mr. Luthi, before we come to you, I haven't really checked with the court reporter. At some time, we're going to need to take a break, so I need to get some idea of, you said a few questions, right? Mr. Luthi, okay? And then Mr. Schrader, few questions, or I'm trying to get in, okay? Okay, and then Novus, Mr. Jackson? Okay, so I'm just trying to think, are we talking about another 20 or 30 minutes? Because if we are, I think it'd be good to just take a break here. So why don't we go ahead and we'll just take a 10-minute break, and we will pick up in 10 minutes from now. So hopefully you'll find your seat again, because it looks like everyone's packed in a little. So we'll go off the record. And just so parties, people that are here, in case you wanted to know, I mean, on other floors there are restrooms, and we have a snack bar downstairs in the basement if you want something to drink.